Welcome to yet another episode of Family with Judy. I know, it's been a while, but we're back. What a mouthful to parents from their children. With me today, I have Carol and I have Judy, the family lawyer. Judy, before the children spoke to the parents, where had we left it off?
We were talking about estate planning, and we had talked about the several ways in which you can be intentional about your estate. We had talked about wills. We had talked about nominating beneficiaries. We had talked about how you could register property so that you do not have to go through the succession courts. We had talked about trusts, and we had said that there is room and there is time for Kenyans and other people listening to us to be intentional about how to have their beneficiaries succeed them upon their demise. I don't know that I can ever say enough about the need for intentionality. We plan for countries. We plan for institutions. We have strategic meetings, strategic management meetings. We hire consultants into companies. But we hardly ever think about the importance of planning for families. And yet we recognize in our constitution and elsewhere about the importance and fundamentality of the family. So we now go into what happens when you do not plan. We look into how your estate is succeeded by your beneficiaries when you leave to meet your maker or whoever it is that you go to meet without having planned how it is going to go to the beneficiaries.
I think you had a name for that.
I do. It is called intested succession. So where there is a will, we call it tested succession. When you don't have a will, we call it intested succession. Let us try and demystify those big words: tested, intested, estate planning. What it simply means, people, is that after we are gone, because of course death is inevitable, it will happen to all of us. What happens to that which you have left behind? And sometimes when we talk about succession, when we talk about wills, when we talk about estate planning, people think of big things like wealth, like buildings and what have you. But no, every one of us has something that they can pass on to their beneficiaries. It could even be your household goods. It could be the clothes you're wearing. It could be your writings. It could be just about anything that you care for. Please let us open ourselves up to the fact that we will go, but also to the fact that we can go better and we can leave those behind us more comforted and more comfortable than we would if we were not intentional about that.
So in the event that one has not planned for their succession and they pass on, what happens the following day?
Interesting question. So of course, one of the things that immediately confronts people is how to deal with your remains if it's the following day, as in the following day. You see, when you plan, you can even deal with matters like how you would like your remains to be disposed of.
Correct.
Okay, increasingly we are seeing people choosing cremation. We're seeing other people choosing, to be buried in public cemeteries, and other people, just making other choices of where they want to be buried. Even that's not a bad thing to do. I think you make it easier, for people when you tell them what you want to do. And by the way, that is also something that can be contained in a will, although the law says there is no property in a body. And the will technically is not to provide for the disposal of your remains, but there is still room, and many people do tell us in the will how they would like for their remains to be disposed of. But if you don't, then of course we'll do it in the way we do best as Africans. Gather our friends together, organize, and put you to rest.
Right.
Now, the greatest challenge, of course, happens after that. So nobody can step into the shoes of the departed person without legal authority to do so. A court gives legal authority to a person to step into the shoes of the departed person and administer the estate through letters of administration. You hear of that a lot, letters of administration. And that is done through a court, as I said. But to get the court to start the process, you need to have a death certificate. You need a death certificate anyway, in all cases, even where you have estate planning. And then after you get the death certificate, you're supposed to go to the chief of your area, and the chief is supposed to indicate, to confirm who are the beneficiaries of the person that has died are, or who the heirs are. So the chief will give you a letter that says this person confirms the person died, and these are the persons that are known to be the heirs.
Okay.
Armed with that document, you can then apply for letters of administration. Letters of administration, basically, or the grant of administration, means that you're asking the court to give you the authority to administer that person's estate. And the administration basically means you step into the shoes and act as if you are them, as in you can transfer the properties and stuff like that, but to the extent permitted by the court. Okay? So you then file a petition for letters of administration, other documents there, quite a number of documents. The court, once it approves those documents, including copies of titles, copies of share certificates, so that, of course, you're not seeking to administer another person's estate, will send those documents for gazettement to the Kenya Gazette. Okay? And the intention is to give the public notice that anyone who has an objection to the application for letters of administration by the certain person has 30 days to object if they wish to. So if nobody objects within 30 days, an interim grant of letters of administration is issued to the person who has applied for them. Now, that grant does not enable a person to distribute the estate, but it enables you to step into the shoes of the person that's departed, so to speak, and to establish where the estate is, or what consists of the estate, you see. So with that, you could go to the bank and ask the bank, do you have, or you could write to the bank and ask, do you have accounts belonging to this person? And how much is in those accounts? You could go to, any office and try to establish what the person has in terms of an estate.
Okay.
Very important. Because after 6 months, or a shorter period if the court allows, you will go back to court and tell the court, this is what I have established to be the estate of this person who has passed away, and I propose that the estate should be distributed in the following manner. So you see, if you don't have the opportunity to establish the estate, you may then not know what the person had.
Correct,
you see, and maybe some of the things you thought were there are not even there. So that's why the interim grant is actually very important. It is important to know the law allows a maximum of 4 administrators in respect of a particular estate. So it could be 1 to 4, except in the case of an estate that has children below 18, in which case there has to be more than 1 administrator. Okay, that's what happens.
What happens when there's an objection?
So when there is an objection within the period allowed, then the applicants for the grant do not get it, the court does not issue the interim grant.
Okay.
And what then it does is to provide the opportunity for the person objecting to state their case. So you go before a judicial officer so that the court can determine whether the objection is valid or not valid. Okay. One of the objections that could come forth at that point is that a person who is a beneficiary of the estate has not been included in the application for grant of letters of administration, because that application includes the beneficiaries, the known beneficiaries, the known heirs. Okay, and so if you're left out, you can then come and object on the basis of that. Okay, so there are many reasons why people could object. So then, or even a spouse, a person could be a spouse and they have been left out. Okay, so then the court determines whether your objection is valid or not. Okay, and if the court determines that your objection is not valid, then it will allow the persons that had applied for letters of administration to go ahead and get them. If it determines that the objection is valid, then it will make appropriate orders. Some of those orders could be that this person, the objector, should also participate in the administration of the estate. So we have cases where the persons who had applied or person who had applied now becomes an administrator together with the person who had objected. Okay,